Thanks for coming. This is our Worsham Law Firm seminar series we're going to start today. This is our first one. This is on family law, and so we're glad that you're here. I'm going to introduce Dan Brogdon. He's an attorney in our office that handles all of our family law and divorce cases. So I met Dan back when he was an assistant prosecutor. We had a jury trial together, and he beat me, so I figured I better hire him. So I did, and now he's over here working with us at the Worsham Law Firm. So Dan, come on up and tell them all about it.
Guys, I don't mind a minute. Oh yeah. Guys, thanks for coming. My name is Dan Brogdon. I'm the attorney that handles all the family law cases for Worsham Law Firm. Let me tell you a little bit about myself. I started practicing law in 2007. After I graduated from law school, I went to work for the prosecutor's office here in Greene County, and I stayed there for 2 years. During that time, I decisively defeated Mr. Worsham in a jury trial. After that, I went to work for an attorney in Ozark, and I started practicing family law in 2009. And I did some criminal defense as well, but primarily today I practice family law. And I practice family law in every shape and size: divorce, child custody, paternity, modifications. And we're going to go over the basics of all of those today. So without any further ado, we're going to get started. Now, generally there are, a couple is married, there are generally two ways to terminate a marriage. And the most common is a dissolution. And that's your typical divorce. A dissolution is a legal termination of a marriage and must be entered by a court. It restores the parties to the status of single persons. The other way to do it is by an annulment. An annulment is not the same as a dissolution of marriage. An annulment means that a marriage never actually legally existed, and it is only available to parties under certain circumstances. Cases of fraud, for example, if a minor somehow gets married. Examples like that. Now, I don't typically do any annulments. I've never done an annulment because they're very rare. So there is a little bit of a legal difference between the two, but a dissolution is much more common than an annulment. Now, the first sort of misunderstanding I think that most people have about divorce is the state of no fault issue. Under Missouri law, a divorce is not necessarily a no-fault proposition, but it is sort of. And what that means is that a party is not required to plead any misconduct. A party is not required to affirmatively prove that husband or wife has done anything wrong in order to get a divorce. However, fault can be relevant. Fault can be relevant when it comes to child custody. Fault can be relevant when it comes to maintenance, which is what we used to call alimony. And fault can be relevant when it comes to the division of property. Now, the only thing that is legally required for a marriage to be dissolved is that it be irretrievably broken. That's the legal standard, and what it means is that the marriage is so far gone that there is no likelihood that it can be preserved. Now, I've included in here that a spouse is allowed to contest the divorce. In other words, the spouse is allowed to say that the divorce should not be granted. But as a practical matter, that never happens. It's legally allowable, but no judge that I know of has ever forced a party to remain married who did not want to. Another misunderstanding that I hear a lot of is folks tend to think that there is a cooling off period, or that there is not a cooling off period in the state of Missouri, which is essentially would be a policy judgment that would require a couple to stay married longer than they want to in the hopes that maybe they can resolve their differences. There are states that have long cooling off periods. One of those states is Tennessee, has a 2-year period. Once you file a divorce petition in Tennessee, you cannot get divorced for 2 years. In Missouri, it's only 30 days. And it's not technically called a cooling off period, but that is essentially the purpose of it. There's a legal purpose of it as well. The 30-day period gives a party enough time to respond to a petition. After the divorce is final, a court retains control of the case, which is control of the judgment, control over the matter for another 30 days. In other words, the judge can alter, amend, or throw out the judgment within a 30-day period. However, the divorce is final the day it's signed. It is effective the day it is signed. In other words, a party could get married the day after they get a divorce decree. However, if there is an irregularity in the judgment, or if there's a mistake in the judgment, or if there is something in the judgment that renders it void, then the judge retains control over it for 30 days after he signs it, he or she signs it. Now, the next point sort of ties into what I just said a few minutes ago about judges not making people stay married who don't want to. Under Missouri law, the court has statutory authority to order the parties to marriage counseling. I have practiced family law for about 5 years now. I've never once seen a judge order anybody to do this. But it is something that a judge can. Now, before I talk, I've got reconciliation up here. Before I talk about that too much, I wanted to mention a couple of things that I left out of the slideshow. Now, when you file for divorce, or when a divorce case gets filed against you, in every county in Missouri, and especially every county in the southwest Missouri area, you're going to be required to take at least one education class. And in Greene County, that education class is entirely handled by the court, in fact, it's scheduled by the court, and it's essentially a class where it's called an alternative dispute resolution class. It is designed to basically convince you that you should settle your divorce case rather than try in front of a judge. So you spend about 2 hours listening to that. Now, the other class would be a children's first class. And if you have kids in a divorce or in any custody case, you have to take children's first class. The idea behind that class is that your kids and their interests are more important than you and yours. So, and that's something, if you get a divorce and you're in divorce court and you're talking to a judge, you're going to hear a lot. And we'll talk about that a little bit more later. But I wanted to make you aware that there are requirements that you have to follow in a divorce case that are independent of hiring an attorney, independent of appearing in court, and independent of discovery obligations. A reconciliation. Now, certainly you can imagine a situation where two parties file for a divorce and then they decide they want to work their issues out. There are several ways to accomplish that, but the most obvious is that the parties simply file a joint dismissal, and that ends the case. Now, the second point is that if the counter petition has been filed, then you have to have the dismissal jointly. In other words, if a counter petition has been filed by husband, for example, then wife cannot simply decide to dismiss the divorce. If she does, then husband's counter petition still exists, and husband can still get the divorce. If you do this and you decide again to get divorced, then the process starts all over. And that's filing a petition, having the other party served with process, and getting into the discovery phase if that is what's necessary. All right, now this is, without much of a doubt, the most important part of any divorce case, paternity case that involves children. The first point is probably the most important. If you don't know anything else, and if you don't get anything else out of this presentation, then you need to understand that the judge who's going to decide custody issues cares about the best interests of your children rather than yours. It comes up because it does not cease to amaze me what people will do to their children in order to get to the other party. You have to understand that judges know that this happens. They see it multiple times per day, every day, and they will punish you for it. So, when you go talk, if you're in a divorce and you're going to litigate custody and you talk to your lawyer about what kind of things you can or need to do in order to win the custody battle, the number one thing that you can do to win the custody battle is always put your kids in front and lead them. Statutorily, or under Missouri law, judges consider 8 factors when they make custody determinations. And they are listed in the statute 1 through 8. The last one is the wishes of the child. And I bring that up because I hear a lot of, my son wants to live with me. My daughter wants to live with me. My kids don't want to live with their mom. My kids don't want to live with their dad. And the fact of the matter is, oftentimes these children are 8 years old, 5 years old. They're not old enough to be making those decisions on their own. And for judges, it is much more important that either parent is willing to facilitate contact with the other child. This is the number one, and they'll tell you that. They will tell you that point blank. The number one thing I care about, the number one most important factor is which parent is more willing to facilitate contact with the other parent. There are 6 other factors, and those include mental health of the parents, the child's adjustment to the home and community, and things of that nature. But the number one most important is which parent is more willing to facilitate contact with the other. A guardian ad litem is an attorney who might be appointed by the court to represent the children. Now, there are 2 circumstances under which this occurs. Number one is, if somebody makes an allegation of abuse or neglect, then the judge must appoint a guardian ad litem. The other circumstance is simply within the judge's discretion. A party requests that a guardian ad litem be appointed, and the judge determines that it would be in the best interest of the child to do so. If you have kids and you have a custody dispute, but you don't have any abuse or neglect, then you still it may still be in your best interest to have a guardian ad litem. Because what a guardian will do is not represent you, not represent the other party, they'll represent the best interests of the children. They may interview the children, although that's usually a last step. They may pull records, they will interview mom and dad, they will interview people who are close to mom and dad, they may conduct home visits, and they will contact the other attorneys. At the end of that process, the guardian ad litem will make a recommendation to the judge, which 95 times out of 97, the judge will follow. Now, the next point essentially is that joint custody essentially means shared responsibility. What people tend not to understand about joint custody versus sole custody is that joint custody does not mean 50-50 time joint custody, or necessarily. Joint custody does not necessarily mean 50-50 decision making. Joint custody means that both parents have input and decision making responsibilities, that both parents are to confer with each other as to every decision, especially the major decisions, regarding the child's upbringing, school, religion, medical care, and the list goes on and on and on and on. I say sole custody is rare and reserved for abuse, neglect, and failure to co-parent cases, and essentially that's true. Under Missouri law, judges are required to prefer joint custody. In other words, they are required to think about joint custody first and determine that it is not in the best interest of the children prior to making an award of sole custody. Sole custody is, if joint custody means shared responsibility, sole custody means the opposite. It means that one parent is going to have all the authority to make all the decisions, especially the major ones. Sole custody does not necessarily mean that the other parent gets no parenting time. There are a number of cases where a judge will grant sole custody to a party, yet give the other parent significant parenting time. Weekends, holidays, summers, etc. Finally, just a note about third-party custody. Judges will not consider third-party custody unless both parents are simply defective. They just will not do it. There are only two ways to get third-party custody under Missouri law. You have to have a party, a grandparent, for example, intervene in a divorce case, or a grandparent, for example, or some other adult person has to file for a guardianship. The guardianship is simply a petition to take over the custody and decision-making rights of a minor child whose parents are unfit, unwilling, or unable to do that job. Now, getting into, in divorce cases, for the most part, you're going to have to divide all of your property. And the purpose of, first of all, the purpose of an interim domestic relations order is to basically freeze everything in time and in space. So assume that you file a petition for dissolution of marriage and you have a house, you have cars, you have children. When the divorce case is filed, the interim domestic relations order goes out with the summons that gets served, which is physically handed to the other side. That order goes into effect immediately, and there are several bullet points to the order, but the most important are that the custody and visitation situation remains in effect the way it is when the parties are served. And that if the parties still live together, it is up to the parties to determine who's going to live in the marital home, at least until temporary orders can be issued. Under Missouri law, the property division that is approved by the judge has to be what is called fair and equitable, but it does not have to be 50-50. I mentioned conduct earlier, how conduct can be important in a number of different settings. Number one is property division, as the conduct of a party, in other words, cheating on a spouse, hiding assets, abuse, neglect, can be very relevant when it comes to property division. There are cases that have gone to the courts of appeals and the Supreme Court of Missouri that have held that it is perfectly acceptable for a judge to divide property 85-15, 90-10. In other words, if anybody tells you that the conduct of your marriage is not important because Missouri is a no-fault state, they're wrong. And this kind of situation really illustrates why. A couple of presumptions exist when it comes to dividing the property between two people who are getting divorced. And essentially, they are divided between non-marital and marital property. Anything that is accrued prior to the marriage is presumed to be non-marital property and is not subject to being divided. In other words, if wife has a car prior to the marriage that she obtained prior to the marriage, then she's going to keep the car no matter what it's worth and no matter what her conduct was. Everything accrued or obtained after and during the marriage is presumed marital property and essentially is fair game. It's subject to being divided. That includes retirement accounts, that includes savings accounts, and that includes accounts for children. Now, just briefly to touch on paternity. Mother and father were never married, but there are legal rights that still need to be established. Then you do a paternity action in court. And what a paternity action does is determines that a person is or is not the father of a minor child, and custody, visitation, child support are all included in the paternity action. Under Missouri law, you're allowed to require a party to undergo a DNA test in a paternity action. Now, traditional versus administrative means this. Traditionally, if you have this issue, you go to court, file a paternity action, and you get a judgment from a judge. An administrative action is simply related to child support. An administrative action simply determines paternity and establishes a support obligation for usually dad. But it does not establish visitation or custody rights. An administrative action simply, there's no court involved, but it simply establishes paternity and child support. Now, after a divorce is final, after a paternity judgment is final, custody, visitation, support, and maintenance, which is what we used to call alimony, all can be modified. And a modification is commenced by filing a motion to modify in the same court that handled your divorce or your paternity. And the process actually works exactly the same way as a divorce or paternity. You file a petition, the other side gets served with a copy of it, and a trial gets set. Now, under Missouri law, you have to be able to prove that there are changed circumstances that render the original order unreasonable. In other words, if you have a parenting plan that calls for mom or dad to see the kids every other weekend, and the kids start to get older and decide they want to live with somebody else, and you need to go to court and get a brand new parenting plan, that's what a modification is designed to do. Or if you lose your job, or your ex-spouse loses her job, or you get a raise or a promotion, you make a lot more money, and child support needs to be changed, you would have to go through a modification to do so. As far as custody determinations go, a modification, the best interest of the child will still control that custody determination, no matter really what has changed. Now, I say it's generally better to get it right the first time, and what I mean by that is that a divorce itself costs a great deal of money, and custody battles can be very emotional as well as expensive. Unless you have a very good strategic reason not to, you are better off to try to do everything you can to get the best custody, visitation, child support schedule that you can get the first time. Because modifying a judgment or decree of dissolution is very expensive, very emotional, and can have your kids tied up in court for several years as it is. Now, another issue that I hear a lot of where that people just don't quite know the rules is regarding relocation. So suppose that you get divorced and you decide that you want to move, you get a job offer in another state, and you want to move. You can be allowed to do that, do it without proper notice. Missouri law specifically delineates the steps that you have to take. And some of the steps that are required are a certified letter to the other party, return receipt requested. You have to give them 60 days notice of your move. If you are moving out of state, you have to tell the other party what you propose your new visitation schedule is going to be. You have to tell the party when you're moving. You have to give them your new address. You have to give them a new phone number. You have to be very specific in what your plan is, and you have to ensure that that party has received that notice. The other party is allowed to file an objection to that relocation, and if they do, then you're back in court. And essentially you're in a modification at that point, because there's no real difference between a modification of a custody decree and a hearing about relocation, because essentially what you're trying to do is the same thing. Now, the most important thing, well, there's two very important things. Maybe the most important is that if those requirements are not followed to the letter, the other parent can seek sanctions up to and including modification. If you up and leave, the other parent can have your children brought back, and you can lose custody of them. And judges, well, they hate parents who take off their kids for no reason. They hate it because it's underhanded most of the time, and they hate it because it creates legal and practical difficulties that both parents end up having to deal with. and it shows a marked lack of the willingness to co-parent. The judges simply, whether it's right or wrong, whether they should in one case over another, they tend to put that over and above everything else. Finally, a little bit about costs. This is obvious stuff, but this type of litigation tends to be very expensive. And you have attorneys, you have court costs, you have filing fees, you have discovery. And discovery is the process of exchanging financial documents, answering written questions, potentially showing up to an attorney's office to answer questions in person, then a deposition. You have time off work, you have potential counseling costs, whether it be for yourself, your spouse, your children, you have the property division, and you have the tax implications. So you have to be aware going into getting a divorce that it's a really significant financial event. Now folks, that concludes the presentation portion, and now I'd open it up to questions. And if there aren't any questions, then I'm going to stick around here for a little bit. So if you want to talk informally, I'll be here for a while.
Perfect.
Thanks, guys.
Awesome.